You've made this unreadable, Garrett said, flicking the pages of my red-lined contract like it was junk mail. Just sign the clean version. He leaned back in his chair, smug as hell, like he was auditioning for a Cialis commercial. I sat across from him in that oversized glass fishbowl of a conference room, watching the light bounce off his $600 haircut and land square on his ego. It was a $120 million supplier agreement. One clause wrong, just one, and the whole thing could turn into a hand grenade. I'd stayed late for weeks, cross-referencing indemnity layers, risk triggers, the force majeure clause that was so vague it might as well have been written in crayon. My notes weren't chaos. They were armor. But Garrett? Garrett didn't like armor. He liked speed, optics. Streamlined efficiency, as he called it, while gutting 3 teams his first week. So when he slid the clean version across the table, stripped bare of every protection I'd inserted, I didn't argue. I didn't protest. I just nodded like a good little footnote in his highlight reel and said, "Of course." Then I walked back to my desk, printed out my version, the real one, and slid it into the back of my desk drawer, right behind my lease agreement and a bottle of ibuprofen. Dated, signed, metadata intact. I knew better than to fight someone like Garrett head on. You don't stop a man like that with logic. You stop him with evidence and timing. By the way, if you've made it this far and you're listening, do me a favor, subscribe and like the video. I know, everyone says it, but 97% of folks don't, and this team puts in serious hours to tell these stories right. It helps more than you think. All right, back to the disaster. The real insult wasn't that he deleted my red lines. It was that he did it in front of the entire legal team with a performative scoff and a line I'll never forget. Stop overcomplicating things. He said it loud, theatrical, like it was part of a TED Talk no one asked for. And then he smiled, that fake corporate smile that doesn't quite reach the eyes, and said, "We need to move. It's Q3 already. We ship this Friday." Ship. Like we were mailing birthday cards, not binding ourselves to a multi-million-dollar supplier with known fulfillment gaps and 6 prior arbitration cases under its belt. He hadn't read the supplier's dispute history, or maybe he had, and just didn't care. I cared. I joined the company 6 years earlier as a junior contracts associate. Back when people still thought red lines were signs of diligence, not negativity. I didn't climb the ladder by charming people. I climbed it by surviving deals that should have buried us, by remembering every clause no one else bothered to read. But Garrett? Garrett was brought in by the new CEO to modernize operations. That was code for make things prettier and faster, even if it meant hollowing us out from the inside. He sent the clean contract to signature that afternoon. I wasn't looped, not even CC'd. My version, the one with Section 12 still intact, was nowhere in the signing chain. But I kept the time-stamped copy, backed it up twice, and created a private folder labeled Langston Cleanup. You don't light a match without a fire extinguisher nearby. The next morning, Garrett stood in the open-floor cafe, sipping some drink with collagen powder in it, bragging to a director about cutting the fat from legal. "Risk-averse people kill growth," he said. I overheard it from the hallway while waiting for the printer to warm up. My name wasn't said, but it didn't need to be. No one asked why I hadn't signed the contract. No one even noticed. That's the problem with being the person who does the invisible work. You're only missed when something catches fire, and by then, it's too late. So I waited. Quietly. Every Friday, I updated my personal log. Every email, Slack, and version trail, recorded, copied, watermarked. Not for revenge, for protection. Because deep down, I already knew how this was going to go. You don't delete legal protections from a $120 million contract without a body count. And Garrett? Garrett was about to learn that complexity doesn't kill companies. Arrogance does. Garrett strutted into the Friday closeout meeting like he'd personally ended world hunger. The flat screens in the strategy room were already glowing with bullet points. Operational efficiency, contract finalized, Phase 1 implementation, green. It was 4:17 p.m., and the energy in the room was that smug, caffeine-humming corporate kind, where everyone just wants to toast something so they can start their weekend early and pretend the real work was theirs. I was standing at the back, not on the agenda, Not even a seat at the table. I had to wedge between a coat rack and the giant promotional banner from last quarter's Velocity Wins campaign. A junior marketing analyst offered me half a smile, then looked away. No one asked why I was there. No one noticed I hadn't been part of the contract sign-off chain. Not Garrett. Not legal, not procurement. The whole thing had been fast-tracked without me, and that was no accident. "Ladies and gentlemen," Garrett announced, slapping a copy of the executed agreement onto the glass table like a trophy fish. "We got it done." The room broke into polite claps. Even Janet from compliance was clapping. Janet, who'd once lectured an intern for formatting a non-disclosure clause in Times New Roman instead of Arial. Now she was grinning like Garrett had just cured her migraines. "Minimal back and forth. No drama, no delays," he went on. "We stopped overthinking and just executed. Clean and simple." I could have laughed if I weren't so exhausted. What he meant was, we signed something risky and hollow, but at least it's fast. He didn't mention that he'd bypassed standard council review. Didn't mention that procurement had flagged discrepancies between delivery schedules and actual supplier capacity in Q2. Didn't mention that I'd flagged 3 separate arbitration outcomes against the supplier, all related to failure to deliver. No, all that had been scrubbed under his doctrine of just ship it. And now they were celebrating. Champagne flutes came out from some back cabinet like this was a product launch, not a compliance risk masquerading as a win. Garrett held court in the center, one hand in his pocket, the other gesturing like he was already being profiled in Forbes. He didn't look at me once. Not when he toasted cross-functional excellence. Not when he thanked everyone who contributed to this flawless delivery cycle. Not even when Janet mentioned, with a wink, that this kind of speed wouldn't have happened under the old regime. I was the old regime, apparently. The last holdout of cautious contracts and devil-in-the-details diligence. In their minds, I'd become the bottleneck, the one who made things hard, and now they were free. Free to screw themselves in high definition. The worst part? The applause. That polite, nodding, back-patting rhythm of corporate groupthink, where no one wants to be the one to say, "Hold on, who actually reviewed this?" Because nobody had. The legal analyst who filled in for me had a 3-month tenure and a fear of commas. Procurement signed under pressure, assuming Garrett had already looped me. Finance? They just needed something billable on the books before quarter's end. And I stood there, smiling softly, the way you smile when you know your house is already on fire and everyone's congratulating each other for turning off the smoke detector. My hands stayed clasped in front of me. I didn't correct anyone. I didn't make a scene. I just watched as the first domino clicked into place. The supplier had a 2-week grace period in the event of non-performance. The next shipment was due in 11 days. And when it arrived, and it would arrive short, or defective, or mislabeled, just like before, there'd be no legal recourse to hold them accountable, because Section 12 was gone. Gone like I was from the contract chain, erased like my notes, my caveats, my caution. No indemnity clause, no force majeure buffer, no language requiring performance guarantees. It was a skeleton contract with a smiley face on top. And when it fell apart, it wouldn't be Garrett's name they called first. It would be mine. Because the cleanup always falls on the quiet ones. The ones who don't shout during meetings or pour bubbly over Gantt charts. The ones who remember every sentence that should have been in bold. Every clause that was intentionally deleted. The ones who build the firewalls no one sees. Until they're gone. That night, I stayed behind after everyone cleared out. The conference room was still warm with the scent of champagne and ego. I pulled out my notebook, opened my laptop, and logged one final entry. Contract executed without review. Signatories. Garrett Langston, head of the strategic ops. No council sign-off. No indemnity clause. No warranty clause. No escalation procedure. Timestamp. 5:42 p.m. I clicked save. Then I opened my drawer and checked the backup drive. Still there. Still mine. And then, with the office dark and empty, I whispered to myself what they refused to learn. A fast contract isn't a smart contract. And somewhere in that silence, I knew this wasn't over. Not even close. It started like these things always do, small enough to ignore. A mislabeled shipment from the supplier warehouse in Nevada. Instead of 6,000 units of component B, they sent forth 800, half of which were scratched or warped. Some intern in logistics flagged it in a Slack thread with the casual panic of someone who still thought the system would catch mistakes before they mattered. Garrett responded with a thumbs up emoji and wrote, "Handle it. We've got more coming Tuesday." That was a Monday. By Thursday, the second shipment didn't arrive. No call, no explanation. Just a vague email from the supplier's regional coordinator citing unexpected transit delays, and a reminder that the current agreement does not stipulate replacement timelines or failure to perform escalation procedures. I sat at my desk, rereading that sentence 3 times. It didn't stipulate them because Garrett had deleted the clause that would have enforced them, the clause I had written. Section 12, line 3, the indemnity clause, gone. I scrolled through my local files, not the shared cloud versions. Garrett had access to those, and by now had probably had legal scrub them clean of any inconvenient metadata. No, I opened the one stored on my encrypted local backup, dated 3 months prior. The file name, mlriskrev3, final, not approved.docx, timestamp. Friday, 11:12 a.m., less than an hour before Garrett had deleted all my annotations. There it was. In the event of supplier error or breach, client reserves the right to demand, at supplier's expense, immediate replacement, financial restitution, or termination without penalty. I sat very still. That clause was our teeth, our only teeth. Without it, the supplier could ghost us, and we'd still be on the hook to downstream clients waiting on those units. Without it, we were a ship with no anchor, no leverage, no protection. And sure enough, by the following week, the supplier sent a formal notice. All parts shipped meet industry tolerances. Further claims will not be recognized under the current contractual agreement. It was a legal middle finger. Short, cold, final. And Garrett? He did what men like him always do when the tide turns. He disappeared behind layers of plausible deniability. Suddenly, the logistics team hadn't followed up fast enough. Legal hadn't reviewed the clause thoroughly. Procurement had failed to log the dispute properly. It was everyone's fault but his. At Tuesday's triage meeting, he stood at the head of the table, arms crossed, and barked out questions like he was a hostage negotiator instead of the guy who walked us into the hostage situation. Did anyone escalate this to legal? Who confirmed the fulfillment clause? Where's the original backup of the contract? I didn't answer. Neither did anyone else, because they were all realizing something at the same time. No one had seen the original clause. No one had printed it. No one had saved it, except me. Later that afternoon, while the department scrambled to draft apology memos and talk-off scripts for our clients, I sat at my desk with my screen tilted just slightly away from the aisle. I opened the file again, scrolled to section 12, highlighted it. I checked the metadata logs, unchanged since that Friday 3 months ago. Untouched, untampered. Then I did what I always do when the building starts to smolder. I documented. I exported the file as a PDF, saved it with a new timestamp, created a cross-reference log linking the clause to the supplier's standard breach patterns, archived it twice, once to my local backup, once to a secure private cloud. Then I printed one hard copy, just one, and I placed it in the same drawer where the others waited. The thing about watching a slow disaster unfold is knowing exactly where the fault line started and exactly how it was ignored. You don't yell. You don't interrupt the chaos. You let it unravel, line by line, until someone finally realizes they're holding a knife with no blade. Garrett hadn't asked for my input since the champagne toast. He'd stopped replying to my Slack messages, ceasing me only when optics demanded it. But now he was starting to look over his shoulder, because the supplier had made it clear they weren't playing ball. And someone, soon, was going to ask who signed off on a $120 million contract without a binding liability clause. That answer was already written. It was waiting. And when the question came, I would simply lift the page. By the time the third client threatened to escalate their complaints to executive leadership, Garrett called an emergency meeting at 7 a.m. because nothing says accountability like blaming other people before coffee. I wasn't invited. From what I gathered afterward, it was textbook. Garrett pacing in front of the whiteboard, drawing arrows between departments like he was solving a murder, when really, he was the one holding the bloody claws. Legal was slow to verify performance safeguards. Procurement had approved SKUs without confirming warranty terms. Logistics failed to document product discrepancies properly. Every sentence he spoke had one thing in common. My name wasn't in any of them, and that suited me just fine. Because while Garrett was playing hot potato with blame, I was sitting 2 floors down, quietly reviewing the digital audit trail he hoped no one would notice. I had version logs, draft metadata, revision notes, and a full Slack archive of the morning he deleted my red lines, including the message that started it all. Garrett L. Stop overcomplicating things. We need this done today. I'll clean it up. I remember staring at those words back then, hands still on the keyboard, wondering if I should push back. I didn't. Not because I agreed, but because I knew better. Paper trails don't lie. People do. It was 11:43 p.m. when my phone buzzed on the nightstand. Unknown number. I let it ring twice before picking up, still half awake, voice rough from sleep. Maya Lynn? Hi, Ms. Lynn. It's Tyler from Legal. Tyler Dempsey. I hope it's okay I'm calling this late. I couldn't sleep. There was a pause, too long to be casual. What's wrong? I asked. I was reviewing the supplier contract, he said. His voice hushed, like someone could hear him through the phone. Specifically Section 12. It's basically empty. I know, I said. Another pause. He exhaled slowly. Do you, by any chance, remember what used to be there? I didn't answer right away. I sat up, turned on my bedside lamp, and reached for my laptop. I do, I finally said, but let me show you instead. Within minutes, I was logged into my secure drive. The folder was already there. Langston edits unauthorized. I uploaded the file, PDF version, original Word doc, timestamp log, and Slack screenshots, all watermarked, all dated, all clean. Then I created a new share link and dropped it into a private email. To Tyler Dempsey. Subject: Supplier Contract. Section 12. Attachments: see enclosed files for original language and revision history. Confirm receipt. I hovered for a moment over the send button. Then I clicked it. Tyler replied 4 minutes later. One line. Thank you. I knew I wasn't crazy. That was the moment I realized Legal had started sensing what I'd known since the champagne dried. The paper trail was broken. Garrett hadn't just deleted a clause. He'd shredded the connective tissue that made the whole agreement defensible. And now, even the interns could feel the draft was off. The next morning, I arrived to find the usual manufactured calm, the hollow greetings, the soft lighting, the diffused panic hiding beneath productivity metrics. But there was a subtle difference. Legal walked past me slower. Procurement gave me long looks from behind coffee mugs. One director even stopped mid-hallway before deciding not to say anything at all, because Tyler had talked. And once someone in legal starts asking why there's no version control on a $120 million agreement, eyes start moving, fingers start pointing, but not at me, not anymore. I didn't need to defend myself. I didn't need to raise my voice. All I needed was that one question, whispered after midnight. Do you remember what used to be in Section 12? Because that meant they finally understood. Someone had removed it, and someone else had proof. The escalation letter landed at 9:12 a.m. on a Thursday, wrapped in a threadbare apology and 3 paragraphs of legal indifference. The supplier's in-house counsel, some icy operator named Chloe Bernhardt, cited 3 lines from the signed contract and concluded with a sentence that knocked the wind out of half the legal team. In absence of performance-specific obligations, no liability shall be inferred or assigned to supplier under the present agreement. Translation: You're screwed. Our defective parts had made it downstream. Clients were livid. One of our top-tier OEM partners in Texas halted production and issued a formal breach notification. Another sent us a 2-page PDF titled Failure Timeline, complete with annotated screenshots and a suggestion that we revisit internal quality assurance structures. One client actually used the phrase, regretfully reevaluating vendor alignment. Corporate for, you've got one more shot. Altogether, the ripple effect of those faulty shipments cost the company $19 million in missed commitments, late fees, emergency overnight part replacements, and contractual penalties. And Garrett? He spent that morning in the executive war room trying to spin a crisis narrative that didn't mention himself. I heard he brought donuts. from the nice place, the kind with brioche dough and artisanal glaze, like you could sugarcoat $19 million in damages. I wasn't invited to that meeting either, but I didn't need to be. Because while Garrett held court over breakfast and buzzwords, I was at my desk reviewing the most dangerous weapon in my possession: the truth, documented. The Slack thread where I flagged warranty gaps. The email I'd sent legal the week before the signing titled RE Indemnity Language Urgent. Garrett's "Stop overcomplicating things" reply, still preserved in the timestamp. Meeting notes from the internal huddle where he told Janet, "We'll take the risk. It's better than looking slow." He had taken the risk. Now the risk was taking him. I'd started cataloging everything: file versions, edit logs, sign-off chains. I built a private timeline in Notion, color-coded, date-stamped, cross-referenced with delivery failures and client complaints. Every time someone CC'd me by accident, I screenshotted it. Every time I was excluded, I marked who was present instead. This wasn't just CYA anymore. This was building a vault. Garrett was still trying to keep me out of strategy discussions, which told me one thing: he didn't yet realize I had the original clause. Or he suspected, but thought I'd fold under pressure. That was his second mistake. His first was thinking a clean contract was better than a correct one. By the end of the day, the executive assistant sent out a calendar invite for something called Downstream Risk Mitigation, Strategy Sync. Half the org was on it. I wasn't. I stared at the invite for a long moment, then opened my backup folder. Section 12 was waiting exactly where I left it, with the signature block, with my notes, with the highlighted clause Garrett had cut without discussion. In the event of supplier error or breach, client reserves the right to demand, at supplier's expense, immediate replacement, financial restitution, or termination without penalty. I highlighted the clause again, copied it into a side document labeled "Would have prevented 19 million DocX," and smiled at the absurdity. Then I saved it. Quiet revenge isn't loud. It's methodical. It's the cold comfort of knowing that every smug meeting you're excluded from is another line added to the ledger of your eventual vindication. Garrett still thought he could outpace the fallout with enough slide decks and action verbs. We're optimizing our supplier relationship. We're aligning deliverables with expectations. We're reinforcing client partnerships. He was throwing words at a fire. But I had the matches, the fuel, and the receipt for the extinguisher he threw out when he deleted my clause. They didn't see it yet, but the courtroom would. By the end of the week, the whispers had gotten louder than the all-hands updates. You could hear it in the hallway between finance and compliance. Conversations cut short when someone walked by. The legal team stopped eating lunch in the break room. Garrett started showing up in the office at 6:30 a.m., rifling through shared drives and asking IT to double-check version permissions. His voice, once booming and cocky, now carried that frantic edge of a man trying to rearrange chess pieces after someone already called checkmate. The internal audit launched on a Monday, quietly, with no grand announcement. Just a single compliance lead in a blazer walking into the exec wing with a notepad and a tired expression. Everyone knew what that meant. The house wasn't on fire. It had been smoldering for weeks. Now someone had opened a window. By Tuesday, Garrett was a shadow of the man who'd once bragged about cutting the fat. He was snapping at procurement leads, rewriting emails mid-thread, and cornering junior analysts in the hallway to ask things like, "Did Maya ever mention any concerns to you about Section 12? I knew he was scared when he started deleting Slack messages. You don't try to erase history unless you've already lost the narrative. But the thing about Slack is, it remembers. And so did I. I'd exported every thread the day after the signing. I didn't need to confront him. I didn't need to defend myself. I just needed to wait for the moment when someone would finally ask me the right question. It came on Thursday. A closed-door meeting, legal, compliance, Garrett, the CFO's advisor, no agenda. Just a quiet, "Please join us," from the chief counsel's assistant, who avoided my eyes like I was walking into an execution. Garrett was already seated when I walked in, hands folded, laptop open, smile a little too tight. "We're trying to clarify the origin of certain language, or lack thereof, in the supplier contract," the chief counsel began, her tone clipped. "Garrett informed us you were involved in early drafting. Is that correct?" I nodded once. "That's correct." "And you submitted a redlined version for review?" Yes. Garrett leaned forward, cutting her off. And as I said before, the red lines were extensive, much of it overkill. I streamlined them based on standard templates. She agreed to it at the time. I turned to look at him. He didn't blink. I never signed the final version, I said. He let out a laugh, tight, performative. Well, I mean, you didn't object either. Not formally. I didn't respond. We're just trying to understand, the compliance lead said gently, if anyone recalls the indemnity clause that's now missing from the signed agreement. Garrett cleared his throat. Look, we're focusing on what's actionable now, not playing gotcha with earlier drafts. It's not about pointing fingers. I turned back to the council. Would you like to see the version with the indemnity clause still intact? The room went still. Even Garrett froze, lips parted mid-sentence. I have it, I continued, calm as a summer morning. Word doc, PDF, Slack thread, metadata, all preserved. The silence stretched. Dated? The council asked quietly. Time-stamped the morning of the final meeting, with backup logs. Garrett looked like someone had unplugged him. His mouth opened, then shut again. His knuckles whitened around his pen. He tried to speak, but nothing came out. I reached into my folder, slid a printed copy onto the table, highlighted, labeled, Section 12 in full. No drama, no speeches, just paper. Legal scanned the lines in silence. The compliance lead blinked twice. The CFO's advisor didn't look up. And Garrett? He stared at the document like it was a weapon, because it was. He knew what it meant. Everyone did. I wasn't the overcomplicator anymore. I was the only one who had been right. The lawsuit landed like a brick through the conference room window. The Texas client, our largest OEM partner, filed first, alleging breach of contract, failure to deliver, and consequential damages from the supplier debacle that now totaled over $27 million on their end alone. Others followed, 3 in total, 1 in arbitration, 2 in civil court. The legal team stopped using the word containable sometime around the second summons. The board held an emergency vote to form a litigation subcommittee. By Friday, it wasn't just whispers in the hallway anymore. It was dread, echoing through every Slack channel and cascading down from the top like black mold in a collapsed ceiling. The supplier, of course, wasn't budging. Their attorneys clung to the contract like a life raft, highlighting Garrett's stripped version of Section 12 in every response. No warranty clause, no performance remedy, no indemnity. The silence of what wasn't there screamed louder than anything written in ink. And then came the subpoena. It was slipped into my inbox just past 3 p.m. on a rainy Wednesday. Subject line, Lynn, Maya, testimony request, matter, Debrar 4793CV. It was official. I'd been named. Legal had finally admitted, under oath, that I was the original drafter of the agreement in question. The court wanted to hear from the person who had written the protections that could have prevented the collapse. And more importantly, the court wanted to see what happened to those protections and who removed them. Garrett tried to preempt it with a last-minute internal statement, sent company-wide like some kind of corporate lifeline. In large, complex negotiations, he wrote, language evolves, roles shift. No single contributor can fully represent the final legal posture of an agreement. A tidy little erasure, generic enough to sound mature, slippery enough to dodge blame, but it didn't matter anymore. Because while Garrett was still talking in circles, I was assembling straight lines. I cleared off my dining table that night, laid out the files like puzzle pieces. Printed versions first. 2 drafts, mine and the one signed. Then the Slack messages. Garrett's infamous "stop overcomplicating things" quote, sent at 11:08 a.m. on signing day. The email thread where I highlighted supplier arbitration history, the calendar invite I wasn't included on, the signature logs, the delta comparison from Word's version history, a clean timeline, a single narrative, truth on paper. I prepared the packet like I used to prep for finals in law school, quiet, meticulous, without emotion. This wasn't about vindication anymore. This was about clarity, correction. That night, I took a single folder from the stack, labeled it Exhibit Draft, Court Copy. Inside went my original contract version with Section 12, Line 3 intact, a printout of Slack logs including Garrett's direct quote, timestamp metadata of all edits, The deleted clause, annotated internal compliance memo confirming absence of clause in signed version. My formal non-participation in sign-off chain, I sealed it, dated it, placed it by the door. I didn't feel triumph. I felt stillness, a kind of quiet you only get after a storm has announced itself and you know with absolute certainty that the worst isn't coming. It's already here. And now everyone would see it. In court. On the record. Garrett wasn't scared yet. He still thought he could talk his way through it. Still believed that if he projected confidence and shrugged just enough, people would believe he didn't really know. But I knew. The court would know. And soon, so would everyone else. The courtroom wasn't grand. Just another beige rectangle with scuffed linoleum and tired fluorescent lights, like a DMV had cosplayed as justice. But the air was heavy, thick with unspoken consequences. Rows of corporate suits lined the benches, all stone-faced until their phones buzzed with calendar invites or silent messages about client churn and investor nerves. Garrett sat 2 tables ahead, flanked by outside counsel and a junior associate with a laptop that hadn't stopped blinking since we sat down. He wore the same expression he always did under pressure, a brittle kind of optimism, the look of a man who still thought performance could substitute for substance. The judge was a quiet man, middle-aged, glasses low on his nose. No nonsense. He didn't ask for opening statements. He asked for documents, one by one. Then he reached for mine. The packet I'd submitted had been passed to him nearly an hour earlier, quietly, cleanly, with no performative posturing. He held the top page now like it weighed something. Not just paper, but proof. Let the record reflect, he said, glancing over his glasses, that the court is now reviewing Plaintiff's Exhibit 4A, original red line draft submitted by Ms. Maya Lin. Garrett shifted in his seat. His attorney leaned in, whispering fast. I sat perfectly still. The judge turned a page. This is Section 12, he said, voice steady. Line 3. He paused, read aloud. In the event of supplier error or breach, client reserves the right to demand, at supplier's expense, immediate replacement, financial restitution, or termination without penalty. Another pause. He held the page up. This clause, he said slowly, is not present in the signed agreement. Yet here it is, dated and time-stamped, 11:12 a.m. on the day of execution. He looked at Garrett. Who removed this? Garrett blinked. The color in his face drained like someone had pulled a plug. I'd have to check the final review. We used a simplified version for a client delivery. Standard templates were... The judge didn't flinch. Answer the question. Garrett's jaw moved, but no words came out. The silence in the courtroom turned thick. You could feel the collective inhale. Legal. Compliance, former colleagues. Every set of eyes on him now. Then the judge turned to me. Ms. Lin, is this your signature? Yes, Your Honor, I said, clear and calm. That's my draft. That clause was present in every version I submitted. I was not included in the final sign-off. The judge nodded once. He placed the page flat on the bench like it was a verdict in itself. And, to confirm, he continued, this red line was distributed internally prior to contract execution? Yes, sir. Documented? 3 times, with metadata logs and Slack correspondence. More silence. Not angry, not dramatic, just still. The kind of stillness that doesn't beg for attention. It commands it. Garrett didn't look at me. He was staring straight ahead, chest barely rising like he'd finally run out of alternate narratives to stand behind. His attorney had gone pale, flipping through a binder as if he could conjure a justification between laminated tabs. I remained seated. No gloating, no flicker of satisfaction. Just the quiet relief of the truth. Undeniable, printed, under oath. The judge tapped the page once, gently, like sealing a coffin. We'll take a short recess, he said, and when we return, I expect clarity from defendant's counsel regarding chain of custody decisions on this document. Everyone stood. The court officer motioned toward the exit. Garrett didn't move. As I gathered my things, I caught a glimpse of someone in the back, an associate from legal, one I didn't know well. She looked at me like she'd just learned something vital about how the world actually works. I didn't smile. There was nothing to celebrate, just the undeniable fact. The clause was real, and I was the only one who had fought to keep it. Garrett was gone by Monday. No press release, no all-hands meeting, just a quiet update on the internal org chart. His name replaced by a hyphen, the space next to it reading interim appointment pending. People noticed, of course. Not because anyone missed him, but because his calendar disappeared from the shared directory and the suite he used to occupy was suddenly dark, the frosted glass doors permanently shut. By Wednesday, the board issued a memo. In light of recent legal exposure, it read, we are initiating a top-down assessment of our internal contract governance processes. That was code for, we saw the courtroom transcript and we're not taking another bullet for a man who couldn't read Section 12. The damage was done. Settlements were in negotiation. Clients had to be wooed back with desperate discounting and promises of reform. The whispers in the hallway turned into questions, then into stories. By Friday, I had 3 missed calls from senior leadership, 2 emails flagged urgent. The third message came from the General Counsel's office, a formal offer to step into a newly created position, Director of Legal Risk Strategy, reporting directly to the executive team, full autonomy. Name on the org chart this time. I didn't even open the compensation packet. Because it wasn't about money. Not anymore. I didn't need a title to do my job, and I didn't need an office to know my work mattered. I already had proof, sitting in my drawer like a lighthouse beam that never dimmed, even when they all pretended the storm didn't exist. So I declined. Politely. Firmly. I wished them well. I even wrote the framework they could use to avoid repeating the same failure again. And then I stood up, walked back to my desk, and opened the drawer that had quietly outlived Garrett's entire tenure. Inside, 1 folder, 1 page, the original. Section 12, line 3, still highlighted. I slid it out, ran my fingers across the ink like I was reading Braille, and whispered to myself. Not for drama, not for triumph, just for truth. Complicated saves millions. I placed it back, closed the drawer, and turned off my monitor. Outside the window, the office buzzed with the noise of recovery. Strategy sessions, revised templates, new names trying to undo the mistakes of a man who believed speed was strength. But I didn't need noise. Silence had always been my strength. And now it was theirs, too.